So first we'll see what is the roadmap of the current issues, what we could see the current issues, the current labor law practices. The first one thing is no provision of fixed term employment. Many of the states were not amended with the requirement of the fixed term employment in the Standing Order Act. So there is no commonly, you can't appoint a fixed term direct employment for a fixed term period or contract. If you have any time bound projects, for that also you have to hire through a third party contractor. You can't hire a direct employee under fixed term employment. It is for pan India level. When it comes to provision of gig worker and platform worker, till date there is no clear cut labor law guidelines for the gig worker and platform workers. They will be called as the delivery partners, or they will be called as the business partners. There are various latest terms were used to avoid them from the ambit of the labor law applicability to them. So there is no provision for gig worker and platform worker. Several different registrations, licenses, and exemptions under different acts. When it comes to labor law, there are certain 13 different registrations, licenses required to operate. So there is no common license or the common parameter which applicability. All this has been not clarified under it. So several different registration and licenses required under every legislations. Multitude of returns. And there is a duplicacy and overloop. For example, similar wages, annual returns, similar minimum wages, payment of wages, payment of bonus. Likewise, the duplicacy were happening in various legislation. The similar data will be submitted. So there is no common return under labor laws. You have to file the various different authorities. The fifth issue will be the different authorities responsible for enforcement and inspections. So when it comes to minimum wages and shop and establishment, when it comes to factories, when it comes to payment of wages, payment of bonus, contract labor, all these are handled by different authorities. There is no common inspection model or common enforcement authorities under these legislations. Every legislation have a specific notified appropriate authority under it. So the authorities may come for any time for inspection. So many different definitions of establishment and workmen and wages. When we go across, there are 12 different wages used under labor law. 12 different definition of wages. When legislations restrict the wage limit, the workman definition differs from legislation to differ scope of physical interaction. Though the technology has improved, still many of the states go with physical document maintenance, physical application filing, physical returns, registers to be maintained. All this happening. So there are a lot of physical interaction. The authorities can come at any point of time for inspection. They may ask for a number of years. One authority may say he wants only for 6-month documents. The other authority may ask for 10-year document. There is no certain limitations to ask certain labor law related documents. So every authority have empowered to ask any amount of set of documents that it has to be maintained physically in many of the states. So labor unions can go on strike anytime without any period notice. So other than the essential services, this is what the current issue. The labor union can go on strike by giving a notice. So the finally outcome is total 9% only the laborers were covered under labor laws. Current labor laws, only 9% of Indian employees were covered. So this reform has to address to cover entire thing and simplify the process. So the reform, what the reform is supposed to address? So they extend the scope of coverage of labor law, the gig worker, platform worker, unorganized worker, all these people has to be covered under labor laws because it will give a certain amount of benefit to other employees too. When it comes to social security, when it comes to monetary benefits, family welfare, all this definitely will give a huge impact in Indian industries. The second thing is reduce or eliminate ambiguity in interpretation of the law. There is an ambiguity and interpretation. When it comes to one single definition, we can't assume that the same definition used across all the legislations. The ambiguity will arise, the interpretation will arise because it is not a common definition. Here, the reform addressed to common definition to be given and the meaning supposed to be even for all the legislations. Simplified license and registration, permission and consent orders. The license has to be only through the electronical mode, and the deemed approval has to be processed in it. And if authority not reverted for the physical file or the online filing of the application, the deemed approval process to be given for all the registrations. Certain time limits to be given to the appropriate authority for them approval of the cases. So removal or redundancy of the records. In place of using n number of registers, there are 12 different kind of wage registers. There are different kind of wage slips under every act. There are certain duplication happen here and there. The duplication has to be reduced, and a common register is supposed to be, and it's supposed to be maintained electronically. The legislation is supposed to permit them to maintain electronically. So reduce the inspector Raj, enable self-certification and third-party certification. That is what the reform is supposed to address. So there is an option to be given to the employers to give the self-certification, or the third-party agencies can audit and give the reports to the government to reduce the inspector Raj. In place of inspector, there may be a self-certification or third-party certification has to be implemented under it. We'll see that what and all the key points in this. Before that, the legislation. The current scenario is around 44 legislations, central legislations were identified to made into 4 codes. In this, during consolidation of this, they identified around 15 legislations or the welfare legislation, which is cess-related legislations, which not given any impact to employees and employers as well the government. So these 15 legislations were repealed since 2016. The final outcome is 29 legislation were made into 4 codes. Around 1,232 sections, now it become 480, and 226 sections were removed. So total outcome is 67% has been reduced from the current in this new labor codes. So this nothing but a number of acts attracted to it. OSH code will be 13 acts, code on social security 9, code on wages 4, code on industrial relation 3. I don't want to go in depth into it because everyone aware about this. So compliance burden. Currently, we just analyzed with the central draft rule how the compliance burden has been reduced. Code on wages, they required 3 returns and 12 different registers. The proposed draft rule says that 1 return and 2 registers required to be maintained. Code on industrial relation, 2 registration, it remains same. Code on social security, we say that 4 registration, 36 returns, and about 20 registers has to be maintained under social security, which it says that 1 registration, 4 returns, and only 1 registers required. When it comes to code on occupational safety, 4 licenses, 11 different registrations, and 22 returns, 76 registers required at present. The proposed rule says that 1 license, 1 registration, 1 return, and 3 different registers required to be maintained. It is just a draft condition. This may change because the appropriate authority is central, the draft rules which is published by the central government. When it comes to state appropriate authority, there may be a chance of increase or decrease, but we need to wait for the draft rule or final rule published by the respective state governments. So this is what the key, majorly we have to understand before we go into the labor codes. The first one is appropriate authority. Who is the appropriate authority? Because there is a central government, there is a state government. Now the previous condition are abolished, and they said that the appropriate authority is central for wherever the central paid up capital is 51% or more. And similar way, wherever the controlling industries like oil, natural gas, telecommunication, banking, insurance, kind of listed controlled industries were published by the central government. For them, the central government, mines and other industries were specified in it. For them, it is a central government is appropriate authority. The rules has to be followed as per the central rules. Otherwise, all the other cases, the state rule will be applicable. So power to exempt. The other second condition is power to exempt. There is a condition given to the state government. The state government can exempt certain provisions of the act or certain rules, certain chapters of the act or entire act for certain establishment or registration, because the working hours is limited to 8 hours as per OSH code. But we know that shop and establishment, many of the states, were increased to 9 hours. In this case, certain chapters may be exempted by the respective state governments. Only when they publish the draft rule or notification, we'll come to know the knowledge about that. Different threshold for various chapter, because this all the 4 codes will have certain headings of chapters. Every chapter have various threshold for its applicability. We should understand that which chapter we are reading, and particularly which chapter belongs to how many was the applicability limit, threshold limit. Principal employer more accountable on contract workers. Compared to previously, the principal employer were more on contractual workers. Now the bonus also come under the principal employer responsibility, that if contractor not paid the bonus payment and recover from the contract, pushed to principal employer's responsibility. Enhanced to 3 lakh rupees. Now it has been extended to 10 lakh rupees up to, and many of the legislation which previously fined 5,000, 2,000 and all, it's gone to 50,000, 1 lakh to extended penal provisions. And there is option of compounding of offenses whenever the jail term has been given by the court. During the time, they may go for compounding of the offenses. They have to make the payment of amount as a compounding against the jail term. In that case, the jail term will be recalled. So first one is OSH code. Meanwhile, if you have, you can put it across the Q&A box. I will take last 20 minutes of the time to answer all your questions. For the first code, we'll be seeing that the Occupational Safety and Health Condition Code. The one common license under various chapters, that is factory, CLRA, interstate migrant workmen, building and other construction, and other acts which are covered under this code. The employer can have one single license under all this. So it's not required under various registration or various licenses, which is listed under Occupational Safety and Health Code. Deemed approval has been given in this, all the application filed online. So this is one of the technology platform that the central government imposed, that every application has to be filed in online. Authorities were given certain time limit of 30 days, 45 days limit to revert to that application, whether they have to file objection, rejection, or approval. If fail to do that, the system automatically will approve, and the applicant can download the approved application once the periodicity, the deemed approval period, whichever is given. In that case, the application will be approved, and the license or registration can be downloaded through the online portal. The applicability threshold for the factory has been increased. Previously, we know that commonly it is 10 with the aid of power, 20 without the aid of power. Now it has been for Pan India, 20 with the aid of power and 40 without the aid of power. The contract labor applicability increased. Previously, we know that some of the states even 5, some of the states 20, some of the states 50. This code commonly said that it is the applicability threshold has been increased to 50 and more contractual employees. Godowns will be treated as industrial premises. So it is ambiguity in between the shop and establishment and factory. Now the godowns will be treated as industrial premises. Difference between the employee and workman. This is a very, very important term that we should understand, that the definition of employee and worker in this, all the labor codes, because the employee term covers all the people other than the person who is the managing director or the person who's have unlimited control over the establishment. All other manager, administrative capacity, everyone covered under the definition of employee. When it comes to worker, who do the manual, skill, unskilled, clerical work, the pattern of work will decide that other than the managers, supervisors, all these people will be treated as workers. So every clarification, every applicability, every term where they used employee and worker, we should be very conscious that whether they used employee or worker. Otherwise, it will make a lot of confusions for its applicability and extending the benefits to others. The family term has been the grandparents also included in the terms of family. Previously, the grandparents were not a part of family. Now, grandparents were included. So, ESI and other benefits the grandparents can be availed. Working hours, it says that the normal working hours will be only 8 hours. As I told you, it is very clearly said that it is for factories. When it comes to the similar code is applicable to even for commercial establishment and shops. In this case, the certain state government has to exempt certain professions during the rule or special notification to relax the certain profession. Otherwise, it will go as a 8 hours is a normal working hours. Women allowed to work during the night. Still, many of the states not allowed women to work during the night. This code very clearly says that with the consent of the woman, women can be allowed during the night. It's given option of women to work during the night. Appointment order become mandatory. So appointment order has to be issued. It has become mandatory. Eligibility for increase the leave. Previously, we know that the leave eligibility starts once the employee complete works on 240 days in a year. In the subsequent year, he will be given 15 days leave. Now the term has been demolished. It says that any employee works for 180 days, he will be eligible for earned leave. The leave has to be calculated 1 day for every 20 days of work. It is not in the subsequent year. Once the employee complete 180 days, immediately the leave has to be calculated for every completed 20 days of work for 1 day. The same financial, even the same calendar year, this employee will be eligible for the leaves. Worker allowed to encash the leave. Maximum accumulation has been given 30. Any excess of 30 days can be encashed. Prefix and suffix holidays shall be excluded from avail paid leave. So this is one of the best clarification given under legislation, that any holiday earned leave taken by the employee, assuming that 6-day working establishment, the employee is applied for 6 days. In this case, the previous and the later, the prefix and suffix holiday of the weekly holiday, not to excluded from the availed leave. So the weekly holidays were not to be counted in the earned leave when the employee avail continuously. After a certain age, annual health examination become mandatory, and accident victims, any fatal accident happens, in this case, any employer penalized by the court. In this case, the 50% of the penalty amount will be given to the victim's family. So contractor engaged more than one state has an option of common license. You no need to have a separate license in every state. There is an option of common license which handled by the central government. Though the appropriate authority is state, there is an option for the common license to the contractor under various states. He can go for a central government license. Prohibited the contract labor in the core activities. So it is there, but there is no such enforcement by the authorities. But the legislation given 11 different activities to be engaged by the contractor. Any additional activity engaged by the contractor, the appropriate authority has to identify whether it is a core activity or not. Then only he has to permit the contractual employment in the establishment. Principal employer responsible for principal employer responsible for experience certificate of the contract workers. Any contractor not given the contract employer experience certificate, in this case is responsible by the principal employer. Contractor employed through unlicensed contract labor, any employed by the unlicensed contractor will be treated as a direct employee of the principal employer. So unlicensed contractor engagement is prohibited. So principal employer responsible for welfare facilities of the contract labor. Similar way, the one more new thing is interstate migrant workmen. Previously, we know that the applicability of interstate migrant workmen was very hard and very ambiguity. Now it has been very clear. Any person move from one state to other state and he is hired by any employer by knowing or unknowing. If his salary is less than 18,000 or less, he will be treated as an interstate migrant workman. So additional burden to the employers that they have to pay once in a year the to and fro journey charges to the interstate migrant workman. Though he traveled or not, he has to be made a payment for it. And additionally, when it comes to welfare measures, lunchroom has to be provided for 50 and more workers, canteen has to be provided 100 and more workers, ambulance room 500 and more workers, welfare officer for factory, mine, plantation 200 and more workers, Safety committee for factory 500, hazardous process 250, building and other construction worker 250, and mines is 100 workers. Is the welfare arrangements has to be made by the establishments or factories. So draft rule, it is about the central draft rule. When we talk about registration, any new establishments has to be registered electronically on the Shamshuida. I'm talking about the central rules. So existing establishment already registered under the central, also again they have to re-register within 6 months period. In case if a new application has to be filed by the establishment, it's supposed to be in the form 1 in the electronical way. They have to file it. Annual health examination, the central rule has clarified that any employee who's completed 45 years and above has to be checked annually, that too within 120 days of commencement of the year. He has to be given. There are certain parameters were given under the rule. That parameters has to be checked by the medical practitioner. Safety committee. The safety committee shall meet at least once in a quarter, and if it is a mines or safety committee, at least once in a month. The records has to be preserved. Overtime wage need to be made at least double the regular wages. That has been clarified how to calculate the daily wages, weekly wages, as well the hourly wages has been clarified under the central rules. Inspection. When it comes to inspector, has to provide or facilitate the prohibition of imprisonment notice, and Form 12 has to be given as a non-compliance report on the safety, health, and working condition. When it comes to women employment, between 7 p.m. and 6 p.m., women engagement required consent, formal written consent. It is not electronically, it is not a group of people were accept in a common agenda. It should be a formal written consent has to be received to engage women during night. Adequate transport facility for pickup and drop has to be provided. Welfare facilities has to be extended. Same way, ICC, when it comes to POSH Act, Sexual Harassment Act, it says that 10 or more employed establishment required to form the ICC committee, but this code says that any women employee engaged during night, the ICC, the POSH Act will be applicable on them, the ICC become mandatory for them. So journey allowance, as I told you, the interstate migrant workman has to be paid a lump sum amount to and fro charges. In a second class, second class sleeper second class train fare has to be paid, whether he travel or not, but to and fro once in a year, the employer have to make the payment. Key points in the code on wages. The OSH code over, we are going to talk about the code on wages. Code cover all the employees, irrespective of wage ceiling. Previously, we know that 21,000 and above only will be applicable on payment of wages. All this has been demolished. Even one employed establishment, also this code will be applicable on them. Provision to bring informal workers under the agents of minimum wages. This code talk about the minimum wages and payment of wages terms. For it is applicable for all the people, even one employed establishment. Also, the minimum wages has to be made. So all the people will be covered under it. When it comes to wage payable to the employees, when it comes to wage payable, we know that the 1,000 and above employee has to be paid on 10th, on or before 10th, which term has been reduced. They have to make the payment by 7th. It has become mandatory for every establishment, whether 500 or 1,000 employee or more than 1,000 employee, they have to make the payment on 7th. Additionally, we know that only on termination or removal or retrenchment, we have to make the payment within 2 working days for the final salary. Here, the resigned employee also has to be paid within 2 working days. Maybe the operational burden will increase. The people who works in HR, they have to proactively settle the employees within 2 working days to avoid the non-compliances. Payment of wage ceiling for bonus eligibility to be decided by the appropriate government. We know that the eligibility ceiling is 21,000, which is decided by the central government at present. But this code says that the wage ceiling has to be decided by the respective appropriate government. In this case, there may be a chance the different threshold limits may be maintained by various states. There may be a chance. Manager and supervisor are now covered under overtime regulation, because this code very specifically use all the employees term for the overtime or excess of working or working hours, all this they use employee term. In this case, as per the analyzation, the overtime wages may applicable to all the employees other than the managing director or CEO, CFO, all the people who have unlimited control over the establishment. Other than that, all the people will be attracted with the overtime payments. State government not allowed to fix the minimum wages less than the national floor minimum wages. Here, one more catch up has been given by the central government. The central government will fix the national floor minimum wages. The state government will fixing the minimum wages. They are not allowed to fix less than the national floor minimum wages. Geographically, the national floor minimum wages may be decided by the central government. So maybe in the northeastern states may have certain impact due to this. They have to competitively, they have to compare with the Delhi, Mumbai and Bangalore kind of cities, or the states which already making the payment of 10,000 or 12,000. If they comparatively, if they want to make it, that drastically the minimum wages may increase the states which have less than the national floor minimum wages bracket. So this is the one of the very, very important where we join to understand about the impacts and definition of wages. So this is the definition of wages. There are two parts in the definition. The first part says basic dearness allowance and retaining allowance is wage. So only three components available here. One is basic, one is DA, another one is retaining allowance. That will be treated as wage. The second part says that the following components were excluded from wage. So the following components were not in the definition of wage. What and all they? Bonus payable. This may be paid once in a year. Value of house accommodation, any house provided on subsidiary basis or any concession provided. HRA as one of the component. Employer contribution on PF and pension, and interest earned by the interest earned by the employee. So the employer contribution of pension, even the NPS also attracted to it for a pension contribution. Conveyance allowance, any conveyance allowance paid to the employee, any travel concession given, and any special expenditure on nature of employment. For example, washing allowance, car allowance, fuel allowance, mobile reimbursements. All this will be treated as a special expenditure for nature of employment, payable under any tribunal or award of settlement, any settlement paid on the tribunal award, any overtime allowance paid, and commission payable. Any salesperson will be getting the commission out of his payments, or any incentive paid. All this will be accommodated in this commission payable. And gratuity payables, gratuity once in a 5 years only it will occurs. Retrenchment compensation, retrenchment on separation only the retrenchment occurs, retrenchment compensation. In this case, other than the gratuity and retrenchment, the remaining compensation not to exceed 50% of the total wages. That is the condition. So the first part, basic DA and retaining allowances, supposed to be 50% or more than 50% in this case, to match the condition of the excluded part not to exceed 50% of the total wages. The second part, as I told you, other than the gratuity and retrenchment compensation, all components, including the bonus payable, it will be paid once the financial year completes, and the commission payable, any overtime, it is on occurrence basis. All this has to be predicted and put across to decide the second part exclusion, which is within 50%. As I told you, the condition, excluded part other than the gratuity payable and retrenchment compensation not to exceed 50% of the total components. So the meaning given that 50% or less to be accommodated in bonus payable, value of house accommodation, any concession, HRA, employer contribution, PF, pension, NPS contribution, and interest earned by the employees, conveyance allowances, travel concession, special expenditure for nature of employment, payable under any tribunal award or settlement, overtime allowances, and commission payables. So all this put together not to exceed 50% of the total components. So we'll see that how the wage work. I given one slide of example how it works. I just took across, this is a wage, this is the component titles. Here, I just took one employee with a gross salary of 12,000, other is 20,000, 25,000, 50,000, or 1 lakh. This is the current salary structure. Currently, I have this structure. You're assuming that this is the current my salary structure. I'm just altering after the labor code. Once the labor code comes, if I am complying to 50% within this part A, basic DA retaining allowance, within this part A, if I am complying to 50% of my total components, sorry, the total component, the CTC, the total components, if I am capturing to 50%, in this case, I can continue after the labor codes. If I am not complying to it, in this case, I need to adjust certain amount from various, the excluded part of 50%. I need to increase within these three components to match the 50%. And whatever may be the financial liability or the impact will match one to one. So first one is the basic. I just took as a 30% from the grass, maybe differ from establishment to establishment. Basic, I just took a grass salary 12,000. I'm not going to CTC. I'm just taking the grass salary of 12,000, 30% of the grass, and I'm just fixing a DA. Some of the companies will not maintain the DA component. They will add it within the basic. In that case, okay. If I have a separate DA component, I'm just fixing for 4,000 rupees as a DA component, and I'm just fixing retaining allowance of 4,360, just matching to the figure. I'm not given any workings here. I just put 40% of the basic as under HRA. The HRA will be the excluded. It's supposed to be within 50% of the total components. So this I just fixed a 40% of the basic, which as per the Income Tax Act, which not to be exceeded 40% for the purpose of tax in non-metro cities. If it is a metro cities, it is permitted up to 50%. And conveyance allowance for tax purpose, I just put 1,600. Travel conveyance, I just not added anything. You may add and see that whether it is matching. Special expenditure for car washing allowance of any. Just for example, I just put a quote over here. Excluded, that is overtime. Any overtime allowances or overtime payment made to the particular employee has to be accommodated in this. This is the grass component, which includes. Other than the grass, there are hidden components, which is talking about bonus payable. I just took approximate 1,000, which are also they excluded within 50%. When it comes to commission payable, any salesperson or any incentives or anything payable, which will accommodated within the 50% of the excluded part. And the employer contribution of PF and pension scheme and any NPS contribution paid, all this put together has to be accommodated in this bracket. So maybe through the NPS, if any employee receives out of interest in this has to be added within this particular component. So this is just for purpose of deduction. I just shown for comparingly take home what will come. So it is not prescribed under this code. The code prescribed the gratuity payable. The gratuity payable will be 2,221, which is already excluded, but not within the 50% bracket. It is excluded part, which is not within the 50% bracket. When it comes to take home or CTC, for current, for current, we know that the CTC will be 14,878 after this labor codes. If I am having the same structure, I'm not changing anything because my total CTC is 14,000. In this, it is exceeding 6,000. So it is more than 50%. So I'm just moving the same component after the labor code. My CTC will increase to 210 rupees per month. When it comes to annually, it will go to 2,520 rupees, because I'll tell you two reasons here. First reason will be the gratuity payable. Currently, we calculate gratuity only on basic and DA component. But this labor code says that gratuity has to be paid on the wage component. So the retaining allowances also will be treated as a wage for purpose of gratuity calculation. So the gratuity liability of the employer will increase. So currently, if you capture 30% of the calculation of basic only for the gratuity, this may go to 50% of the wage to be calculated minimum for the purpose of gratuity. Similar way, if you have a threshold of 15,000 rupees for PF calculation purpose, in this case, you will not have any impact in it if you not maintain the threshold. Though the employee is receiving less than 15,000 salary for the purpose of PF, in that case, well restructuring, probably the financial impact, the reduction may increase, PF reduction may increase. So employees take home may reduce, and immediately the employer has to contribute equally to the employee's contribution. The employer also has to equally contribute. So employer cost also will increase during the restructure. If the employee is less than 15,000, in this case, while restructuring, if the first part, if you increase to it, maybe they may go for higher side of contribution. So employee and employer. Similar way, when I'm going to 1 lakh rupee compensation, 1 lakh rupee gross wages, this similar way I just put across that in this scenario, I could see that in a month, 2,664 will be the impact month on month, which goes to 31,968. The two here I just put across the maximum value, so I'm just maintaining the same. If my value is very less in this case, if I am increasing this, definitely it will increase drastically. Similar way, one more thing I want to highlight here: any establishment contributing unlimitedly without the wage ceiling of 15,000. In this case, you no need to worry about the contribution which is made on basic wages. You can change only the retaining allowance for the purpose. The PF judgment of Supreme Court on Surya Roshni and Vivekananda and others case, it's very clear that the employer contribute 15,000 or more will not have any impact on the particular judgment. So if any employee has the less than 15,000 wages for the purpose of PF, in that case, while restructuring, the employee may have certain impacts. So this is the working. I just took some of the examples. The first will be Part A. Part A is supposed to be fixed within 50%. These components need to be fixed to 50%. Only three components: basic, DA, and retaining allowances. The excluded part, all the exclusion will be allowed up to 50%. That is HRA, conveyance allowance, travel allowance, special expenditure, overtime, wages payable, and bonus payable, commission payable, and employer contribution of PF and pension and NPS scheme. All this put together not to exceed 50% of your total CTC component, that is inclusive of gratuity. So it's very clear that if you maintain more than 50% in this bracket, you will not have certain impacts. So due to this restructure, what are all the impacts? What and how the employee will be impacted or employer will be impacted? See that the CTC, I'm telling that the CTC will increase because only the gratuity payable will increase. Gratuity wages from 4,600, it has come to 8,900. From 31,000, it has went to 86,400. Only the gratuity calculation wage were increased, so the CTC were increased. In case employer want to stick to the old CTC, in this case, definitely this cost, the excess cost of the gratuity, will impact the employee's take-home pay. There may be a chance this, if employers not ready to accommodate, in this case, the employee's take-home may reduce. Similar way, when it comes employer, if you're ready to accommodate this additional cost in a CTC, then employer will have certain financial impact. So this is what the financial impact. Additionally, we see that what are all the cost impacts. You have to restructure your entire structure. If it is not matching to the requirement of the labor code, you need to inform the employees and you have to restructure it. It is physical work which electronically or physically you need to submit the request or intimation to the employees. They have to accept. All this document has to be preserved. So it is a more or less the physical activities involved in it. The second thing, we see that the PF contribution, employer and employee contribution, may increase. Well, restructuring, if any employee less than 15,000 will restructuring, there may be a chance of PF contribution may increase to the employee and employer. So employee will take home will reduce, employer cost may increase. The gratuity payable, as I explained to you, the gratuity needs to, till date we calculate only on basic wages. Now the term has been moved to wages, so the gratuity needs to be calculated on basic DA and retaining allowances. It will go 50% or more. In that case, the gratuity payables will increase. Tax, employee tax. Due to restructure, there are many cases if you have a components on billable, which the exclusion part, if it's come more than 50%, in this case, some of the components you need to move from excluded part to the retaining allowances. In this case, the billable will not work in that case. There may be a chance of higher tax payment by the employee. So employee take home may reduce for in terms of taxability. So gratuity payable for the fixed term employee. Similar way, the fixed term employee is eligible for even for 1 year completion, he will be eligible for gratuity. Till date, it is unanswered question for the fixed term employees. Now, if you have any fixed term employees, they are eligible. They are eligible for 1 year. One year, every completed year, they are eligible for 15 days gratuity payment as like regular employees. They are eligible for every completed year of service. So the fixed term employee will get a gratuity benefit once the code comes to its operation. Reskilling fund. Additionally, we see that the 15 days wages payable on retrenchment. It is addition to the retrenchment compensation. Any employee terminated or retrenched during the time for 15 days wages of the particular employee has to be paid to the reskilling fund. It is an additional financial burden to the employees. That is what the financial impact under this codes. So now the central rule, what it talk about? It talk about the minimum wages. The concept of national minimum floor wages has been introduced. It very clearly said, but this code is not clarified that who is the appropriate authority to fix the national floor minimum wages. This is an unanswered question, and how they're going to fix this, who's the person, who's the committee, or who's the board going to decide all this, it is still not clarified by the central government. And the state government has to notify their minimum wages. It is not less than national floor wages, we know that. And additionally, the central government constituted a technical committee for the purpose of advising for the skill category, because due to various new terminology, new designations were come across, we were very confused that whether this particular category will come under skill category or unskilled category or high skill category. So this technical committee by the central government has took over 681 type of employments, and they categorized into unskilled, semi-skilled, unskilled, and high skilled, and they published the list of designation under the every skills. So working hours and overtime, as I told you, this code on wages rules very clearly says that the for factory purpose act, this OSH for this purpose, the working hours no need to be considered. So it is very clear that the Factories Act 1948 applicability, the OSH code working hours need to be considered, not on code on wages. Normal working hour, when the employee works for 8 hours, only 1 hour interval of rest has to be provided, including any tea break, lunch hour, all this put together, not to exceed 1 hour break. So many of the states go with 1 hour break. Additionally, the employees may take 15 minutes or 30 minutes tea break, all this. Here, it very clearly says that employer has to provide 8 hours work and 1 hour break. This 1 hour including of all the rest intervals. So including lunch break, tea break, whatever may be, all put together, not to exceed 1 hour break. Overtime wages will need to be paid at least twice the regular wages we discussed. Employees who work on weekly rest day are eligible for overtime wage payment. So any employee works on weekly rest day, he is eligible for overtime wage payment. Daily and hourly rate wages calculation clarification provided under the draft rules. So how to calculate daily wages, how to calculate hourly wages, all this has been clarified under. Process for fixing floor wages. As I told you, the committee not clear how to fix the minimum wages, but condition is state government not to fix less than the national floor minimum wages. Process of deduction and recovery not to exceed 50%. We know that payment of bonus, as I told you, principal employer liable to make the bonus payment in the event of failure of payment by the contractor. In case your contractor not making the bonus payment, in this case, you are liable to make the bonus payment. Wage slip, employer mandatory to issue the wage slip in Form 5. There is a format prescribed under this code. Timely payment of wages, enable the principal employer responsible, enabling the contractor's payment to contractor to make the payment on time. So it is not that principal employer not paid to the contractor, so contractor not paying on time to the contractual employees. This is not to happen. It should be the responsibility of the principal employer to make the payment to the contractor on time, to make contractor payment to the contractual employer. Here, the responsibility come back to principal employer. Inspection scheme, digital intimation of inspection has to be given, and silent on specific procedures. It is not clarified that how the procedure will work, what is the timeline, what is the periodicity, nothing is clarified. There's a digital inspection has to be given. Register and record, we said that there are two different registers has to be maintained under it. So maybe the draft rule has provided certain formats about this. This only applicable to the central. When it comes to state, there may be a chance of increasing or decreasing in the list of records. Now we'll be looking at Social Security Code. So voluntary coverage, here the new thing is voluntary coverage. ESI can be voluntarily can be registered. Any establishment or any shop, anything want to have the voluntary coverage of ESIC, it is permitted now. Any construction project value 50 lakhs and above over will be covered under BOCW. Currently it was 10 lakh. Now the applicability of BOCW will be 50 lakh. Any project you have 50 lakh and more, in that case, the building and other construction work will be Work Act will be applicable on you. Extend the labor law coverage, including the gig work, platform worker, freelancer, home-based worker, and informal sector worker. So this Social Security Code covers various gig worker, platform workers, freelancers, home-based workers, all put together, everyone covered under this code. So provision of gratuity has been made for fixed term employee. As I told you previously, there is no fixed term employee will be paid as a gratuity. Now, even if you complete 1 year, you will be eligible for gratuity at the calculation of 15 days wages for every completed year of service. If he crosses more than 6 years, for example, one fixed term employee is 1 year, 7 months, or 1 year more than 6 months, in that case, he has to be calculated for 2 years. Aggregator is nothing but the platform provider of gig worker and platform worker, like Ola, Uber, Urban Ladder. Likewise, there are all the people who has the technology platform for a business. They will be called as aggregator. This aggregator has to contribute 1% to 2% of total turnover, subject to maximum of 5% paid to the gig worker or platform worker to contribute to the Social Security fund of gig worker and platform worker. So it is an additional cost burden for the aggregator to make 1% to 2% of their entire turnover, or 50% which pay to the platform worker to the contribution. This is a draft rule by the central government, which says National Social Security Board for gig workers. So there is a National Security Board will be constituted. The gratuity, as I told you, fixed term employee will be completed a year of service. The gratuity, every additional completed year of service, part thereof, excess of 6 months will be eligible for 15 days wage for every completed year of service. So crutch facility, in this draft rule, Social Security, it's talk about the crutch facility for 50 or more women employee. Previously, we know that during the Maternity Benefit Act amendment, it says 50 or more employees. Even the draft central rules of Social Security, they used for crutch facility, establishment with 50 or more women employees. So we need to see that how the final rule will be published, whether it says the 50 women employee or 50 employee. We need to be very conscious on this. Crutch facilities shall be located within appropriate distance from the establishment. This is central rule. Crutch facilities shall be located within appropriate distance. Previously, we know that it is 500 meter, 1 kilometer, all this clarified, but this rule very blank that appropriate distance. It says appropriate distance. The distance is not clarified under this rule. Facility needs to be extended to women working from home. Even the crutch facility has to be extended the women who works from home. There's a new burden may come after this code. It is only for central, as I told you. The state may change, may not. We need to wait for the state rules. The rules of silent about specifications, how, what, all these clarifications not given under this rule. Intimation of vacancies, as like employment exchange return, it says that in place of quarterly, here it has been introduced annual return, digital way. So it required technology platform to do this returns once in a year. Notification of vacancies, it's similar. When it comes to returns, in place of quarterly return, they introduced annual return. Electronic return has been made. So next topic is about industrial relations code. It is a very important topic for the factories or any establishment who face the union and issues. So in this code, there is a provision to hire fixed term employment. I'm just clarifying you about the fixed term employment. Any within an agreement, within a direct agreement between an employee and employer, anyone can be hired as a fixed term employment for a fixed time period. In this case, this fixed term employee will be eligible for all the benefits as you extended to your regular employees, ESI, PEF, maternity benefit, all this, they will be eligible, all this. But only thing is applicable threshold, applicable periodicity of working is not on them. So 5 years complete of service is required for gratuity, which is not required for them. Bonus 30 days minimum working is required, not required for them. Leave eligibility, certain period has to be there, is not applicable on them. Only the applicable time period is not required for them. Similar way, once the contract period ends, this fixed term employee is not eligible to go for challenging you for permanency or compensation under industrial relations. So once the contract period over, he will lose the job. There may be a chance you may extend the contract period or the new fresh contract can be enforced. The fixed term employee eligible for all the benefits, as I told you, all the benefits. No need of eligibility period. Employer can large model of industrial employment. Standing order will be applicable on 300 employees. So standing order applicability, we know that some of the states 50, some of them 100, some of them now due to COVID period, they increased to 300. This code, the standing order applicability increased from 100 to 300. Process has been laid down to recognize the trade unions. There is a process, which trade union is applicable. There is the support of 51% has to be there, any 20% or more. All these various criticals were given for the recognition of the trade union under this code. A notice of 14 days notice has to be given for go strike by the unions. Any union want to go for a strike, they have to give the 14 days notice. During the notice, there is an option of conciliation proceeding by the government or the appropriate authority. During the conciliation or arbitration proceedings, the strikes are not allowed. So process of dispute management between the employer-employee likely to simplified. Works committee, industrial establishment employing 100 or more workers required works committee has to be formed, and grievance redressal committee has to be formed by the industrial establishment employing 20 or more workers. This grievance redressal committee not to exceed 10 members, that is 5 from the employee side and 5 from the employer side. The total members of the committee not to exceed 10 at any point of time. So number of grievance committees can be formed. There are 2 or 3 or 4 grievance redressal committees, but any committee not to exceed 10 members. So this is applicability threshold for the retrenchment. For a permission from the authority for retrenchment or layoff has been increased to 300. Previously it was 100. Some of the states were increased to 300 for permission, and now it is increased to 300. Any establishment, industrial establishment, want to retrench employee or lay off the employee up to 300 employees. If the total employee strength up to 300, no need to go for permission from the authorities for retrenchment or layoff. If you have 300 or more workmen, in this case, definitely the retrenchment or layoff required prior permission from the authorities. Introduced the reskilling fund. As I told you, 15 days wages has to be paid to the reskilling fund. So here I just quote 3 different scenarios. One is talking about the layoff and his procedures for more than 300 workmen, and retrenchment procedures for 300 more, closing down, any business closing down, and 300 more workmen were working. In this case, what and all the things we need to do. For less than 300, the procedural, only permission is not required. Other compensation, other parameters, what is mentioned here, the intimation has to be submitted to the authority, but only thing, authority's approval is not required. Immediately they can do anything. The first one is layoff. Layoff is nothing but sending out the employee for time being, for non-productivity, or they don't have work for the particular employee. In that case, it is half paid leave. Layoff nothing but half paid leave to the employee. So the first thing is application of layoff to be submitted 30 days before the commencement of layoff. Only 300 and more workers has to be submitted 30 days before the commencement of the layoff to the appropriate authority. If authority not responded, if you file the application, authority not responded for 60 days, in this case, it is deemed approval. 61 day, you can say that it is approved. You may take it as it is approved, deemed approval. The compensation to be paid minimum 45 days in a year. So in a 12 months period, the maximum of 45 days layoff is permitted. The layoff compensation will be 50% of the basic and DA. It means that only the 50% of the basic and DA has to be paid only to the working days, other than the weekly holidays, only for the working days. 50% of the basic and DA has to be paid for a layoff compensation. When it comes to retrenchment nothing but termination of employee. Notice of retrenchment to be served to the authority employees in 3 months advance, even to the employees and authorities for both the cases. 3 months in advance has to be provided. If authority did not respond for a period of 60 days, in that case, 61 day, it will be deemed approval. Compensation of 15 days average pay every completed day of service has to be given to the retrenched employee. When it comes to close down, application has to be submitted same 3 months, it means 90 days in advance. Similarly, 60 days we need to wait for appropriate authorities approval. If not approved, automatically it will be deemed approval. The compensation of 15 days average pay for every completed year of service. As like retrenchment compensation, it is 15, but subject to not exceeding the 6 months thereof. So this is what the layoff, retrenchment, and closing down, compensation and procedure for more than 300 workmen establishments. So there is a draft rule framed by the central government. There is a standing order. The threshold has been increased to 100 to 300. We know that even if you follow the model standing order, you need to intimate in writing to the authority. As per the central rules, you have to intimate the authority that you will be following the draft standing order. And on conciliation proceeding, there is a Samadhan. Samadhan portal has been introduced by the central government, which digital record will be maintained for any industrial disputes for record purpose. Any award passed by the industrial tribunal or any national tribunal, all these documents will be uploaded in Samadhan portal for any reference. Strike and lockout. No notice of lockout or intimation of electronically has to be given to the authority. So it has to be intimated through electronical way to the authorities about the strike or lockouts. Layoff and retrenchment and closure. Notice of layoff, retrenchment, closure need to be intimated electronically. Permission of layoff, retrenchment to be granted electronically by the authority. Worker reskilling fund. As I told you, there is a retrenchment compensation. Additionally, 15 days wages to be paid, which this central rule says that which need to be credited within 10 days of workman retrenched. If retrenching employee within 10 days, you need to make the payment. This payment will be recredited to the retrenched employee after 45 days of his retrenchment. This fund may be used for reskilling the employee. Yeah, we have another 30 minutes time for questioning. So probably I just see that. Any questions? Yes, there are questions. Oh, there are many questions. Yeah, I will go one by one. We have ample of time to answer all the questions. The first question from Mr. Mahesh Babu. IT/ITES industry, which one is appropriate authority? See, the IT/ITES industry is not a controlled industry. So it is the appropriate authority is state government. The state government will be the appropriate authority. Sorry, the one more, I need to go from the bottom, it seems. Yeah. Yeah, Mr. I think Rajini Arya. When these codes will likely to be a law? So this codes, as per the central government confirmation, they planning to implement this codes from 1st of April is the timeline which is informed by the labor minister. The central government will be ready to implement at any point of time. They will be working for that particular arrangements. But many of the state governments still not started framing the rules. So this may take some time to frame the rules. Till such time, in case state like Madhya Pradesh already started publishing the draft rule for public opinion, all this. In that case, if center publish a report for implementation, in that case, definitely there may be an option of following the existing legislation, or the state government may act by issuing a notification to follow the central rule till such times the state government to come up with the particular rules. The second one, is there any different with respect to international worker compensation? No, the international worker stance remains same. There is no as such changes in the international worker term in this legislation. As like international worker, the definition and clarification which is provided under EPF and other legislation remains same. There is no change in the international worker part. So what kind of employees came under the ambiguity of interstate workers? It is applicable mainly to the factories, manufacturing or corporate as well. So interstate migrant workmen, we know that during this COVID time, the state government and central government were running across to find how many interstate migrant workmen were working in different establishments. They are unable to identify because the definition of interstate migrant workman is very difficult. It says very clearly that any employee hired from one state to other state through a contract, through the employment exchange, will be treated as an interstate migrant workman. That is what the current legislation says. But this code has demolished everything. It says very clearly any employee hired by the knowledge or without the knowledge of the principal employer who moved from one state to other state. I'm in one state. If I am moved to other state for my employment, if I hired by the principal employer, my salary is less than 18,000. In that case, I will be treated as an interstate migrant workman. It is not required to be a factory, a commercial establishment, shop. It is applicable to everyone. I will be treated as an interstate migrant workman. So the legislation is very plain. Any employee move from one state to other state, if his salary is less than 18,000, in that case, he will be treated as an interstate migrant workman. I think I've answered. One more, Mr. Sunil Ji. Yeah. Mr. Doshi has asked, how would be bonus payable via stock option be considered? See, the bonus component, which is, we need to say that it is assumptions. We need to assume that whatever may be the maximum bonus payable or the stock options may be given in that, through that, whatever may be the maximum benefit may be received by the employee, or if you have an exact number to it, you may match to it. If you don't have exact numbers, in this case, for safer side, we'll be keeping the maximum limit for that to avoid the legal consequences, because it is very clear that the appropriate authorities may come for digital way of inspection. It is not that the manual inspection, it is digital way. When you upload your registers which you maintained electronically in a ample of time, definitely they will filter it and they will come to know that whatever the components you used, out of it how much comes under the 50% bracket, how much is exceeding to it. In that case, again, the liability will increase. Your liability will increase. There may be a chance of non-maintenance, or there are penal consequences behind this. So it is advisable to maintain within 50%. Definition of wage, second part, not to exceed 50% of the first part. Is it correct? Okay. See, the definition of wage is only three portions are there. The three portions will be treated as wages. That is basic, DA, and retaining allowances. The excluded part of wages, they said that excluded part of wages not to exceed 50% of the total wages. Total wages means it is not talking about the first part of wages, it's talking about the total components. Almost the CTC structure has been used here. Whatever may be the components you use, finally, if you put together, you will come to know that it's talking about the CTC. Your basic wage, retaining allowance, and the DA needs to be fixed 50% or higher than 60%. In more or less, it is matching to the Supreme Court judgment on the PF basic wages. The similar judgment they want to compile to it, so they just put across this retaining allowance as one of part of the wages to match the numbers. We have announced bonus. Should this be considered too in the calculation of compensation or just gross salary? See, the bonus, annual bonus, you're talking about the annual bonus. Should this be considered too in the calculation of compensation? Yes, the bonus payables, it not say bonus paid. The definition says that bonus payables, commission payables, even though you will be predicting some amount, that amount has to be accommodated under it. It need to be considered for the excluded part of 50%. So the bonus payable or commission payable has to be accommodated. Maybe you may take a higher side for your safer. Can you explain, Mr. Pranit has asked, can you explain what exactly the meaning of fixed term employee, contractor or on loan? See, the fixed term employee will be hired directly by the principal employer on contract basis. It is not by the third party contractor. It is direct agreement between the employee and employer for a fixed duration. For example, if I have a project for 2 years period, I want to hire certain group of employees. So if I hired them for 2 years period, after 2 years completion, I can't accommodate them in my role. Though I have 5 lakh employees or 10,000 employees, but I can't accommodate them. I want, once the project completes, I want to eliminate them, or I want to close their accounts and send them back. In this case, as on legislation, only the contractor can do that. Contractor can hire them through the third party contractor. They work for the contract. When the contract period over, they can be removed. For principal employer, there is no such option. Now this legislation given, even the principal employer can hire directly without the third party involvement. They can hire directly for a fixed duration, 1 year or 2 year, a group of people or one or two people, whoever you require. You may hire them through the contractor. For trial basis also there is an option. You may hire them to 1 year period. If you perform well, there is a chance of continuing the service. Otherwise, your agreement over, you may be removed. So it is the option given to the employers to hire direct contract. All the benefits remain same as like your regular employees, leave, bonus, all this will be given to them. Only thing, once the period over, they will be removed. They will not go for challenging your termination. There is no option of going for retrenchment compensation or anything. Once the agreement period over, the contract over. That's all. Mr. Narsimha has asked, employee hired on contract basis or doing core activity. Do you have, sorry, just lost the question. Yeah, sorry, I got it. Employee hired on contract basis or doing core activity. Do you have to make changes in their employment? See, the contractual contract employment is accepted only on 11 different positions, 11 different nature of employments, like security, housekeeping. Like the legislation is very clear that there are 11 different activities were listed. This has to be, this can be accommodated under contractual labors. So addition to this 11 activities, if anyone wants to go beyond this, they want to hire under this. In that case, there is an option. They may apply to the for a contractual employment for the particular activity, subject to satisfaction of the authority, the appropriate authority, approving authority. He has to satisfy that this particular activity will be not under the core activity, or he has to satisfy that this particular activity has to be accommodated under the contractual only. In that case, he may approve for employing under contract labor. Otherwise, there you have to hire the direct employee. There is no option. Richa, normal working hour is 8 hours plus 1 hour break, or 8 hours including 1 hour break. See, this working hours is 8 hours. The break hour not to exceed 1 hour. That is total 9 hours. Working hours 8 hours, 1 hour break. The total hours not to exceed 9 hours. Here only one clarification is given, that this 1 hour break, including your lunch, tea break, all this put together, not to exceed 1 hour. Some of the establishment, they will accommodate 9.5 hours. The employee 8 hours working, 1 hour lunch, 15 minutes tea break. Likewise, they will be splitting into additional time for the tea hours. Now it says very clearly, all put together, the breaking hours not to exceed 1 hours, including the tea break, whatever. Again, Richa, to ensure timely payment of wages, is principal employer mandated to give advance payment to contractor? No. The legislation says that principal employer have to encourage or support the contractor to make the contractor payment, on time payment to the contractual employees. So the contractor not to blame the principal employer not paid on time, so I am not making the payment to the contractual employees. This is a quote which they want to avoid. So the principal employer also made into the account of on time payment to the contractual employees. Contractor making on time payment, no issues by advance, no need of principal employer on making payment. Otherwise, you need to have certain classes in your agreement stating that this particular contractor's payment will be released on so and so time, but the contractor has to make on time payment to the contractual employees. Certain classes may be added in your contractual agreement to avoid the difficulty of this. Otherwise, you have to have certain arrangements for this. Yeah, Mr. Sanjeev, if the contract period is extended or renewed, will the fixed term employee have claim on permanency? No. Say the fixed term employee will be hired only for a fixed duration of period. Once the period is over, then automatically his contractual period ends. In case if you want to have the extension of the contract period, you may issue an extension on it. Otherwise, this contract will be ends. Otherwise, you may have a fresh contract. Once the contract over, you may have the 1st of April, your contract ends. The 2nd of April onwards, you may have additional contract or new contract against it. Or extension can be given for 6 months or 1 year period. But till such time, you will have a fixed duration for this particular contract. In your contract agreement, if you make very clear cut that this is what the end of the date of the contract, in that case, this employee has no chance of claiming the permanency as per this labor codes. Dhanya is asked, if basic DA plus retaining allowance, oh, I lost again. Mr. Aditya, can you please clarify who is defined as a worker? Does the rule set for workers apply to the people working in the IT industry? Yeah, the worker definition very much applicable even to the IT industry, because the worker definition eliminates only the people who are in the managerial category, who's in the supervisor and above category, who's in the administrative category, who's getting the job done through the people supervising or administering. In this case, the people who do unskilled, manual or clerical, all these people will be treated as a workman. So we should be very clear that any code writer, you will be appointing a code writer as an executive, or any person who's appointed in the range of he don't have any reporting people under him. They will be definitely they will come under the bracket of workmen, subject to wage ceiling. There is a wage ceiling maybe prescribed under the rules. We have to wait for it to determine whether the designations and wage ceiling has to be clarified. Under this course, who is the appropriate authority for aviation? Mr. Girish has asked, under this new course, who would be the appropriate authority for aviation? Yeah, definitely the aviation will be the appropriate authority is central. The air transportation service is one of the controlled industry by the central government. The aviation, the air transportation services will be treated as appropriate authority under the central government. Again, subject to support services. If you have any support function on aviation services, we have on airline services, but one IT company will be working behind to support you. In this case, this IT company will come under the central authority. They will go under the state authority, but you have certain offices only for aviation purpose. They will be focused only on aviation and other related things. They will be under the central authorities. Is retaining allowance same as special allowance? Yeah, retaining allowance is just a name will be called, which will be paid to broadly to all the employees every month on month. So the retaining allowance, special allowance, may be the one of the component of retaining allowance. The retaining allowance is not a one single component. There are various allowances attached to it. It will be called as retaining allowances, which paid month on month, to the employees to to make them or adjust their salaries. So this will be called as retaining allowances. Someone has wrote, the State Shop Act will have amended accordingly. EPS in Bangalore, where IT is main business. When can expect that to happen? I think I'm not catching the question. Sorry, the question is not clear. Uh, 681 published list of industry list defined IT ITS will fall under which category? Skilled, semi-skilled, or high-skilled? See, this 681 different designations. It is not about industry. Through the various industries, whatever may be the names, different names, executive, senior executive, there are various names were designated under various industries. All this technical committee has been gone across. So they referred all this and they categorized this into four buckets. That is unskilled, semi-skilled, skilled, and highly skilled, based on nature of employment, based of designation, based of the industry. They accommodated under these four buckets. But certainly we need to see that what designation you will be referring or what nature of job you will be referring to identify to accommodate under which bracket. So we need to see in detail to answer this. Mr. Neeraj has asked, as current rule of an employee who completed 4 years and 8 months is eligible for gratuity as per Act, as nothing mentioned clearly. Okay. See, the gratuity is very clear as per the Madras High Court judgment. Any establishment work for 6 days. Any establishment work for 6 days. the gratuity eligibility will be 4-year completed service and 240 days completed in the 5th year. They will be eligible for gratuity payment, not required to be full of 5th year, or it is not that 8 months. It said that 4-year, 240 days. In case less than 6 days working establishment, maybe 5 days or less than 5 days working establishment, it is 4 years, 190 days is eligible for gratuity. It is for purpose of gratuity. The similar will be used in the labor codes as well. We have another 8 minutes. We have a lot of questions. I'll see that. Mr. Madhu has asked, so if an IT/ITES organization has operation on multiple states, the state orders approving authority will be who, state or central? Because the say standing order has to be only on the all sites across the multiple places. Okay, it's talking about, I think the question is about the standing order. Standing order, here the appropriate authority for IT/ITES will be definitely the state authority. State authority, the rules has to be framed by this state governments to clarify who is the appropriate authority under it. Because the standing order, if the rule says that one common standing order can be used under various branches of establishments, in that case, there may be a chance of one particular standing order can be used in one state. The similar standing order can be used in various branches in the same state. But when it comes to central authority, central, they have to incorporate the other branches in the list of applicability. But as per my knowledge, the state appropriate authority establishments having one single standing order for pan India, it is not possible, because the appropriate authority differs, leave provisions, working hours. There may be a chance of different thresholds and different applicabilities. So we need to wait for the state rule to be under it. Mr. Karthik is asked, wherever management trainees and workman trainees are come under the fixed term employment. See, the management trainees, if you hired them through the contract, in that case, they will be come under the fixed term contract employment. There are two terms. One is the trainee for the purpose of completing their educational system. They will be not called as trainees. They will be called as how to say, any educational requirements. For example, I'm doing MBA. So during the course, I have to complete certain project. For the particular project, my institution has accept me to go for 6-month industrial training. So I'm just approaching you. You will be accommodating me for a 6-month duration to do my project. I'll be helping you in various parameters, but I will be getting only the stipend. One of this employment. This is not called as an employment. This purpose of accommodating me only to complete my project, and I will be giving the educational institution reference to you as it is a requirement of the project. In this case, they will be not treated as a fixed term employment. In case if it is not there, you will be hiring, once the MBA completed a person, you will be hiring them, putting them under you to do a certain project. This case, they will be treated as a direct employees. If you don't have a contract, in this case, they will be treated as direct employees, though you will be called as trainee or whatever name. But if you don't have any agreement under them, then they will be treated as your direct employees. Ms. Sakshi has asked for women employees. So if at time the work time extend beyond 7 p.m. on one day, then also we need to take written consent from women employee. Yes, the answer is yes. Because the legislation is very clear, the women employment after 7 p.m. before 6 p.m. required written consent from the women. If it is not specified 1 day or 1 week or a number of days, even 1 day, if you have a written consent, then only you will be allowed to engage the women during night. One more, Mr. Just a minute. Raghupati, Mr. Raghupati. I'm just jumping across. Continue. Yeah. Someone asked, can I still continue with 12% of the basic SPF contributions as long as the control is okay, contribution is more than 1,800 per month. Basically, is restructuring is required. So, see, this wage code restructuring, the wage component restructuring, it is not for the purpose of PF. It is not for the purpose of PF. It is requirement of the legislation. You need to restructure it. So once you restructure it, there may be a chance of impact to PF where you have less than the 1800 component, 1800 contribution. If you have less than to it, in that case, there may be a chance of increasing the wage limit. In that case, you will have. Once you restrict them under 1800, that is 15,000 wages, 1800 compensation. In this case, any changes, still you can continue to your restrictions, because the Supreme Court judgment on the Surya Roshini and Vivekananda and others case, it is very clear that the components which is paid, which is the wage components which is paid in the other allowances, has to be considered for the wages. The caption up to 15,000. The caption up to 15,000. The other components also has to be considered for the purpose of wages. If the caption 15,000 and above, in case assuming that my basic wages is 15,000 or more than 15,000, for retaining allowances, whatever maybe I have, no need to worry. Still, I will be maintaining the 15,000 in my basic wages. After the restructuring also, I'll be continue contributing the same 1,800 rupees. There is no need of any changes because I will be given certain threshold limit. I'm just exceeding to it. No need to worry. This is as per the today's scenario. There may be a chance the threshold limit increases, then probably we'll have certain different thresholds. Yeah. Mr. Pankaj Pandey has asked one question. According to the wage code, medical insurance, health insurance is covered under the CTC component or not? See, the insurance as a component. If you say it is a component, you will be making the payment. You will be making this insurance payment to the employee's account. In this case, definitely it will be treated as wages. But in case you will be making directly payment to the insurance agency, you'll be not showing one of the component in your CTC structure, or you'll be not making this component as one of the wage component in the employee's workings. In this case, this will be not treated as wages. So if you make this component wage payment directly to the employee, or you will be mentioning as one of the benefit to the employee in the wage part, in this case, this will be treated as a component. If you will be not showing it, in that case, it is not. I think there are a number of questions. But probably the time is very less. We will try to collate all this question and we'll share you across. Along with this slide presentation, with this your questions, we may accommodate all this, and we will publish this for your reference purpose. This may help you to go through and refer and come back to us with your updated questions. We may ready to give any point of support in terms of compliance knowledge. We have a huge panel people to address the compliance issues as well, the labor law related compliances and technological platforms. So thank you everyone. Thanks for joining. Thanks for patient and listening. We'll catch back in the other session. There may be a chance of any new changes come. We may accommodate one more session for other changes or the draft rule published by the state government. We may catch up to understand in deep details about the rules which may be published by the central. Thank you all. Thank you, Chandana.